The proper procedure, number 2, the proper procedure is to lead evidence against the accused employee, giving him an opportunity to cross-examine the said witnesses and explain the document which appear against him. Depending on the seriousness of the issue, ask the accused whether he wants to give any further explanation or where the issue has gone against him. Or is there a publish? So once that is over, ask the respondent to examine his witnesses and himself if need be. You know, when the evidence on the part of the accused is over, you are saying that the evidence of the accused is concluded here. The evidence of the complainant is concluded here, and now I am allowing the accused to present his case. Then the accused presents his witnesses, and he examines his witnesses, and the employee, the woman who is the complainant, is allowed to cross-examine the witnesses. That is the second part. So he will examine his witnesses in his defense. He will also be allowed to produce any documents, if any, at the appropriate stage, and he can examine himself as well. Once he has done that, parties have given the evidence. The woman employee has given all the evidence. He has given all the evidence. You ask these people to sum up. What have you in sum and substance said? So she said, she will say that according to the evidence available on record, and that which I have produced, this man is guilty of so-and-so deed that he has done to me. The other man will say that according to the evidence I have produced, I have not done this, whatever. So this is the sum and substance of the evidence available to you, on the basis of which you have to come to a reasonable conclusion as to whether any alleged sexual harassment has taken place or not. Now, before I go to the next slide, I just want to draw your attention to 3 case laws, which will help you in coming to a conclusion as to how to evaluate these evidences. One person is going to say this incident has taken place. Another person is going to say that the incident has never taken place. Given this situation, how do you come to a fair conclusion on whether the incident has happened or not? The first one is the Meritorious Bank. Meritorious Bank was a bank in UK, a very small bank, in which they had appointed a manager in one of the branches. An old man like me, who used to sit in the branch, and he used to see a young girl going to school, with all her books and all that. And her father was one of the customers of the bank. He used to come in sometimes for banking. The girl used to walk in and look at the manager with all curiosity, because the managers always are suited, booted and all that. The young people will always find, these people must be very high positioned people. So while going slyly look at him and smile, this man will smile back. And this went on for a few years. As she grew up, as she would walk in the streets, she would wave out to him, and the old man, to make his presence felt, also will wave. This continued for some time. She passed her O level, 12th standard or whatever, and came up to the branch manager and asked him, "Sir, I have a question. Can you give me a job? You think I am good enough to work in the bank?" He said, "Of course you are good enough to work in the bank. I know you, I know your father, I have been seeing you walking around all the time, last 8 years or 4 years, 5 years, whatever. So please come and join me as a teller." So she goes and joins the bank. And then she is very obliged to him. A very highly regarded man, fatherly figure, elderly person at that. So all the time, if he smiled or waved out or said something, she would be delighted. Right? Now, one day, the man comes to her and says, "Look, child, I have not brought my dabba." Now, whenever a person says, "Child, don't trust him," that includes me also. "I have not brought my dabba. Shall we go out for lunch?" For us, when we join companies in small positions, even a small gesture from a superior, big man, is a very big thing. "Oh, he called me for lunch today." I used to say that, when I was saying, when the personal manager is to call me and take me out for lunch and give me a peg of gin or something like that, I would be in seventh heaven on that day, saying that he is the very best man in the world. So this girl also fell for that. They went to a hotel, had their lunch, and he proposed sex. She said, no, you are like my father. He says, no. Father is father. I am not like your father. Now, she thought over. I've said no. When I go back, I would have lost my job. And if I lose my job, what do I go and tell my people at home? Why did I lose my job? So she quietly agreed. And this continued for a period of about 4 years. Regular lunches, dinners, etc., etc. And finally, she fell in love with another young fellow, quite naturally. Who will want all these old people hanging around there? And then she said, no, this is not on. And complained to the bank. The man was sacked. He went to the court and said, this is consensual. What I have done is consensual. Now, Thelka, that is his defense today. Right? But if you look at the act, there is nothing like consensual and all that. Act says, it is an unwelcome conduct on protest. The act speaks of unwelcome conduct. It doesn't speak of consensual sex. And therefore, with that judgment, some big people will have to run for cover, number one. The second case I want to narrate to you is, so you know when a case comes and somebody says it is consensual, you know, you need not examine the issue from the point of view of consensus. Rather, the point has to be examined is from the view whether it is unwelcome or not. If the girl has said, no, you can't touch me, you can't touch her, finished. QED, that's what you say, no? Full stop. The second case I want to draw your attention is to the Saudi Arabian case. 5-10 minutes? 5 minutes? Yeah. The Saudi Arabian case. In this case, what happened was, the secretary was denied her promotion. So she went to the boss and said, why is my junior promoted and why am I not promoted? The boss said, oh, promotion is no issue. Come to my house at 11 o'clock night time. Have dinner with me. Let's have a drink. Talk about your promotion. She said, no, obnoxious. He said, no, I am calling you seriously so that we can have sex. Promotion is granted on a platter. She says, no. Then he started harassing her. Every day there will be requests for lunches, dinners, you know, come sit late at night, this, that and the other. She got fed up. She went to this man's boss, middle-aged man, went and told him that this is what is happening and this man is forcing me to do all this. I have been denied my promotion. I need to know why it is denied. And you need to stop this man on his tracks. He says, you are right. How stupid of that man. He shouldn't have asked you this. You don't go with him, but you come with me, he said. The poor lady. I feel sorry, you know, you got all enactments, this, that, and the glamorous things, all that you have. But as he said, act is one, implementation is another. So actually what happened was, she applied for leave, saying that it is intolerable to work here. When she said it is intolerable to work here, they dismissed her. And then the court, when the matter went to the court said, how do we solve this issue? And the only evidence that was available was this lady's statement. There is no other evidence. Nobody has seen this. Nobody had heard this. This lady has said, and the Supreme Court said, this lady's evidence is sufficient. You don't need any other evidence. So the number two principle that you have to then follow is, when such cases come up, first find out whether the complainant herself is so vehement and so honest and forthcoming. You look at the eye of the person, that will tell you stories about that person, you see. You just say, thump your table, put your hand in your conscience and say, whether that person says is right or not, you will have the answer with you. It is not necessary that, like the courts, you need a host of witnesses to come and deliver their side of the story, you see. Just one witness of the complainant is sufficient enough. Third story. I will conclude with my third story, sir. Third story is the story of Apparel Export Promotion Council. I forget these names, becoming old now, you see. In this case, the chairman called the manager and told him, "You stupid fellow, bring your secretary, I need to dictate a note." And where he wanted to dictate a note? He wanted to dictate a note in Taj. So the boss says, "You have to come, the boss is going to give you dictation, and I will of course help you because I know English better, and whatever pronunciation words he says, I'll be able to fill up gap, don't worry," and all that. Give enough solace to that girl, confidence to that girl, took her in his car, they went to Taj. The chairman, the great dictator, we all like to dictate those days, the great dictator dictated the note. And once the note was complete, she was told, "You go and transcribe, key in, and take a printout and bring." So this officer told, "Sir, I will go and help her." Chairman said, "Okay, you go and help her." So he went, sat near her, very uncomfortably close. And as she started typing, he would touch her inappropriately. And she said, "I don't need your help." He said, "But you do not know English because you make spelling mistakes while speaking. So I'll be able to help you as far as English is concerned." She says, "No, still I don't want you." He says, "No, I'll help you." And she went to the office, wept there, and one of the ladies asked her, "What happened? Why are you not well? Should we call the company's doctor? What is wrong with you?" And she blurted out this incident, that this man tried to touch me, it was very difficult. How to work in this condition. This became an issue in the company. And the company took up the matter of the case of the officer, went up to the court and said, "After all, what did he do? At best, he tried to touch her. And where is the proof for all this? Are you with me? What did he do? Tried. Actually didn't touch. Tried." And the real issue is, where is the proof for all this? It is his word against her word. Whose word do you believe? Now the court said, "Look here. The mere attempt to touch, that itself is sexual harassment. You do not actually touch. Mere harassment, what did he say? Mere effort to touch is sexual harassment." One. Number two, evidence you are asking. Evidence is this: that girl went to the office, and when asked by the girl who is sitting next to her, she said that this is what happened there, and the girl has come and deposed. That is proof. Now, you know from all the service rules that you have, the principles of natural justice you have, it is possible to come to an equitable conclusion on the basis of the evidence available from the evidence of the complainant, from the evidence of the accused, who says, "I only tried to touch," or who says it is a consensual thing. You know, all these things can be just swept aside, because this is a law. I want to conclude by saying that this is a law which is specially made for women, for their protection. And the women who are talked of are women right from the low class society, who are sweepers in a place, to the highest of them. Right? Some of them may not be in a position to complain. So as Mr. Prabhakar rightly said, you help her to frame the complaint, the complaints committee. But when it comes to the proceedings of the complaints committee, you need to go only on the basis of what a reasonable man will do. Don't get clogged down by all these legalities. Because the court knows that you are not legal persons. Right? So on the basis of whatever comes to you, you give your findings. Once you give your findings, these findings should be given to the complainant, you should give it to the accused, and tell them, I want to hear you now on why this finding should not be finalized. This is the second opportunity that is provided under law. That second opportunity says, hand over the findings to both the parties, they come and make their submissions again. Once they make their submissions on the findings, then you come to your final finding. Right? And on that final finding, you give your recommendation and the punishment, if any, if you feel that that man is guilty. Now, I will not go into the other details because I think it is all covered sufficiently. Fine and dismissal, etc., the punishment aspect. You know, Mr. Gowda will cover them in a little more detail. Anyway, that handout is there. What consideration will go into those findings, you see. These are the essentials of the inquiry. Don't you ever get frightened. Children, go ahead and thumb the table there in the internal committee meeting. Thank you very much. It's nice talking to you.
No. In fact, we'll take this. He clarified, he said that the act mentions respondent, but he has used the word accused. Some places, let me complete. What you're saying is true, and Prabhakar had brought this out. The act does not use the word accused, but uses respondent. So take it as the same, because what happens is, in domestic enquiry, one had been using this terminology accused, but it's respondent. Krishnamurthy, thanks a lot for the presentation that you have done. In fact, he has covered up 3 factual cases which took place in terms of sexual harassment. Tried to explain you. See, one of the reality in all these cases is that getting evidences is not going to be easy. So you will have to go by what the complainant says, and this is going to be the crux of this type. The other difference is that in the domestic enquiry, normally you had one domestic enquiry officer that was doing it. Here you have a committee that is going to do, because that's what the Act has laid down. Our next speaker, we'll give chance for question answers, we'll take that later, is Mr. Gowda. He's an advocate, he's the joint secretary. Devappa Gowda, he's the joint secretary of Karnataka Employees Association. He's also going to cover up the case laws that are there, because it's important to try and understand a lot of this is the previous case laws. One thing we must also bear in mind that the Act is new. So litigations on it have still to take place. So unless litigations take place, the clarity of the Act does not come. But the reality is that this is the legislation, and one will have to operate within this legislation. So, Devappa Gowda, floor is yours. Try and confine the presentation to 20-25 minutes. We will cut down on the lunch time, and you could take it up till 1:15.
Okay, no problem. Well, friends, we had sort of 3 stages in the discussion which we had so far. The subject has been properly introduced by Mr. Ranjan Malhotra in his own characteristic style. Then it was followed by Mr. B.C. Prabhakar's presentation on the statutory provision. He has made the presentation in a user-friendly manner, in the sense that you need not go into the entire Act. If you have time, and when you go back, please read his slides within another 1 week. If you do not read it, I am sure you will not read it any time at all. The next presentation was done by Mr. Krishnamurthy. He has given the full details of the inquiry. He has explained within about 30 minutes the whole concept, which would have otherwise taken 2 or 3 days. The agenda for our discussion now has got 2 parts. The first part is the findings of the inquiry. In the sense, you have got the complaint, you have conducted the inquiry, now you have to write the complaint. So my job here is to give you a format of arriving at the findings. So arriving at the finding is a very important step in the entire proceeding of the committee. It should contain the name, who, how, what is the format? Kindly, I am just going to give you a format. It should contain the names of the members of the committee. If any of the members of the committee are not present on all the days of the hearing, it should be recorded. While the order sheet or the proceeding should contain the details of each day's proceeding, the report may only contain the summary of the proceedings held on each day of the sitting. Next slide. Then, after the details are recorded, the committee should record the gist of the complaint against the respondent. If the allegations relate to a different dates and the occasion of these allegations should be recorded chronologically, care should be taken to express no opinion at this stage. The list of documents filed in support of the allegation should be listed and numbered chronologically. The same procedure should be followed with regard to document produced by the respondent in support of its case. Next slide. The gist of state